Welcome, everybody, to this crash course on the California Consumer Privacy Act. I'm Margot Kaminsky. I'm an associate professor of law here at the law school and the director of the Privacy Initiative here at Silicon Flatirons. I wanted to be pretty brief in my remarks so we can get right into the substance. As many of you probably know, the California Consumer Privacy Act was passed in June 2018, shortly after Europe's General Data Protection Regulation went into effect. The reason I give you this timeline is because back in May of 2018, I think there was a flurry of privacy notices, and everybody sort of took notice, looked up and said, wait a second, why are all these privacy notices going out? And it was because of the EU's GDPR. You all may similarly have seen a flurry of updated privacy notices in the last couple of weeks, which I'm sure today's panelists will have a chance to talk about in greater detail, and likely reflect the fact that California Consumer Privacy Act is going into effect in January. So for those who are counting, that's in 1 month. It will then be delayed in enforcement until June, although again, I think our panelists have some thoughts on what exactly that means. And it represents, if I'm going to give a very broad overview, a first attempt within the United States at a truly omnibus data privacy law. What do I mean by that? Well, on a federal level in the US, most of our privacy laws are sectoral, which means that they govern particular sectors like healthcare or particularly vulnerable populations like children. We don't have a single uniform law on a federal level that covers data privacy. Instead, what we have on a federal level is the Federal Trade Commission, which is our all-purpose consumer protection agency, which also does a considerable amount of data privacy enforcement. However, states have proven to be norm entrepreneurs and law entrepreneurs in this area and have been coming up with various sectoral proposals over time. What makes the California Consumer Privacy Act particularly strikingly different is that it's not sectoral. It governs, as we'll be talking about, personal data in many different areas. And its definition of personal data is perhaps the broadest that I've seen, even including the European Union's General Data Protection Regulation. So without further ado, I want to make sure that we give David plenty of time to give us a more in-detailed overview of the CCPA. I would like to introduce our panelists today. To my immediate left, we have Chris Schatz, who is a graduate of both the University of Colorado undergrad and received his JD from this fine institution of Colorado Law. Chris actually worked for David, who is sitting to his left, before before becoming a practitioner in the, at KO Law Firm. And then to Chris's left, we have David Zitouni, who is a partner at Bryan Cave, and both an employer of a number of our students, former students, and a huge person in the field of data privacy. I mean, truly his practice is in both DC and Colorado, and now increasingly in California. And if you talk to people in the field, they recognize his name immediately. To David's left, we have Liz Harding, who is a dual qualified attorney in both Colorado and the United Kingdom, which means that we are fortunate to have in Colorado one of the leading experts on not just American law, but the General Data Protection Regulation. So Liz can bring into this conversation a significant amount of expertise on how the CCPA compares to what companies already have to be doing under the GDPR. So without further ado, I'd like to hand this over to David Zitouni. Thank you.
Great, thanks. See if I can work this. So I think all of us have presented on the CCPA before and on the GDPR. When I agreed to give an overview of the CCPA, I didn't really look at the fine print that it was 20 minutes. To give some context for GDPR, and Chris was involved in this, we did an hour program for each component of the GDPR for a 7-hour program. And for the CCPA, the shortest we've done it so far, I think, is an hour and a half. So this will be the speed version of what the CCPA requires. Let's see. Oh, there it goes. All right, so I'm going to skip over some things that are partially relevant, but maybe not fully relevant, and just gloss at what really the takeaway is here. So as Margot said, timeline, CCPA came into being shortly after GDPR went into effect. I'm not going to go through the twists and turns of the timeline, except it has a tortured history. It's not how typical statutes come into being, if everybody knows from their First year legislative class, how a bill becomes a law, which is how I learned all about legislation. Throw that out. Like, this is nothing about Schoolhouse Rocks. They have nothing on the CCPA. So we have a hostile referendum item that was being put forward that the legislature did not agree with. Legislature ultimately tried to preempt the referendum item that was being put forward by substituting their own piece of legislation. And if you look at the timeline, this is the really important part. Do I have a little pointer? Great. So CCPA is rushed into consideration June 21, 2018, and it is passed unanimously June 28th. So 7 days between the introduction of the CCPA and passage, which is a land speed record for any legislature, California not excluded. And it really reflects that. You know, the original version of the CCPA had so many drafting errors, comma errors, miscites, misquotations. There were portions of it which they had copied from the GDPR, and they forgot to change the terminology. So it was referring to personal data, not personal information. The former is a GDPR term, the latter is a CCPA term. Really not the best in legislative drafting. It's been amended now 7 times. So shortly after it was originally passed, there was an initial amendment to fix some of the commas, some of the statutory miscites. It didn't hit all of them. And then more recently, in September of 2019, we get 1, 2, 3, 4, 5, 6 amendments that passed out of, I think, 17 or 18 that had been proposed. There were other amendments that were on the table that were to fix other issues, some of which were drafting, some of which were substantive, some of which were from the privacy advocates, some of which were from the business community. Attorney General proposed regulations came out in October. What's next? Final regulations. So those proposed regulations, the comment period just closed last Friday? Yeah. And so we probably won't see the final regulations until maybe March, April, May, June, whenever they get around to actually publishing. All right, so land speed, going through this. Scope of the CCPA, it applies extraterritorially to all entities that do business in the state of California. Nobody knows what doing business in the state of California really means, but we all assume that they'll look to the long-arm jurisdictional statute of California and judicial interpretation of that. If that's what they actually look to, that's a pretty liberal interpretation if you remember back to civil procedure class in terms of how far a state can go in terms of legislation. There's some idea about a small business exemption, which we'll probably talk about a little bit later during the panel. It's only supposed to apply to companies that collect data about 50,000 devices or consumers. It's important to realize that that's devices, not just consumers. Gross revenue is greater than 25 million, or these are disjunctive. 50% of the revenue is being derived from selling or sharing personal information. So scope, Margot already indicated this, but January 1st, 2020 is when the statute becomes effective. That's not when the Attorney General is allowed to bring an enforcement action. He can't bring an enforcement action until July 1st, 2020. There's an open question as to whether or not he may try to bring an enforcement action on July from actions that occurred after January. Scope of the CCPA. I'm not going to get too far into the definition except to reiterate what Margot said. Personal information is incredibly broad, arguably even broader than the GDPR, and the GDPR was about the broadest thing any of us had seen until the CCPA came along. So high level includes everything that relates to an individual or that's capable of being associated with an individual. How far that ultimately goes is going to be a judicial question. All right, so what does it really require? On the left-hand side, I put the individual rights that it confers, the security issues that it has, and then service providers, and that really goes into the selling of information. So very quickly, you have to give notices to data subjects or consumers. These are California residents. They have a right to access information that you have about them or that's collected about them. They have a right to ask the information you collected from them, difference in prepositions, be deleted. They have a right to opt out of the sale of information. They have a right to receive services on equal terms. And what does this mean? There's a provision in the CCPA that says if they exercise any of these rights, you cannot discriminate them in most situations by charging them more money, giving them different discounts, or giving them different services. On the security side, this is a little bit of a farce. So there's a provision in there that implies that you have to have appropriate data security to protect sensitive categories of information. That already existed under California law. It's just codified into a different section. It's recodified in the CCPA. But the real kicker here is damages. So currently, if you have a data breach in California, there are no statutory liquidated damages. What the CCPA does is not really tell companies that they have to go out and protect information. That obligation already existed. But that if there is a data breach following information that was not reasonably protected, companies now can be subject to huge statutory liquidated damages in terms of class actions. And then service providers. So one of the kickers of the CCPA that does not have an analog in European data privacy is that it defines the sale of information as a transfer of information to a third party and receiving in return monetary or other valuable consideration. That is a sale. That definition does not match anything that you're going to find in any other statute in the United States, nor really if you asked any consumer what they think a sale is. Usually a sale is, I give you money in exchange for something. That's part of what could be a sale. But any other valuable consideration, that's an open question as to how far that goes. And one of the main concerns in the business community, which I think you'll hear all the panelists talk about today, is when a company enlists a vendor, or what we'd call a service provider traditionally, to do services for them. So the company is actually paying the company to do services. They may be giving personal information. That company may actually be the recipient of a sale of data. They are giving consideration back, the performance of services, unless it falls under one of the exceptions to the sale of information. One of those exceptions is for quote unquote service providers. But service providers is a defined term, and that's why I put it here. It means that there are contractual requirements in the agreement that prevent the recipient of the data from sharing, disclosing, or retaining the information beyond providing the services. So how does this map over towards compliance? Boils down to information notices or privacy policies, data subject request protocols. So if somebody makes an access request, a right to be forgotten request, or an opt-out request, having protocols for how you receive those, handle them, respond to them in a timely fashion in a way that is accurate. Reviewing marketing practices, making sure that there are no inadvertent discriminations. There are a lot of situations which I don't think the people who were drafting the CCPA intended when they said you can't discriminate. Discrimination sounds like a bad thing, except for the fact that in the business community, it's done every single day. And so there's a lot of use cases like loyalty programs in particular, which we may talk about a little bit, where somebody gives their information, they're going to get a discount or accrue benefits, they're going to get free cups of coffee. Then they say, delete my information. They want to exercise a deletion request. And then all of a sudden, all of those accrued benefits are going to go away because they're no longer part of the loyalty program. That may be a form of discrimination under the CCPA. Written information security plan. As I said, there's nothing new in this in California, except for the fact now there's huge damages, which I suppose is the really new portion of it, which also feeds into incident response plans. Again, that's something that's very typical in the business community that companies now for the past 10 or 15 years have built incident response plans. The importance of them is elevated given the potential exposure. And then finally, third-party vendor management. That is what it sounds like. We all know what it is to handle our vendors from a contractual standpoint with regard to every asset or every facet of the relationship, from liability limitations to indemnifications. On top of that now, we have these contractual obligations that need to be built into those contracts in order for them to be guaranteed to be service providers and therefore exempt from the sale of information. So very quickly, I'm going to go through each one of those things that I put on the left-hand side and just give a very quick overview in terms of what it means. Privacy notices. As was mentioned in the introduction, there is no omnibus federal law on privacy notices, but there's no shortage of laws for data privacy. It's a patchwork. We have got Gramm-Leach-Bliley, HIPAA, FERPA, COPPA, and on the state side, we have a number of states that already had statutes that required any company that collects social security numbers to give privacy notices. And we had other states, including California, which already had statutes that required any company that did the online collection of information to give privacy notices. The net result is that if you look around to most companies, I think there was a study done about 8 or 9 years ago, it's pretty out of date, but about 95% of US companies had an outward-facing privacy notice. So there is a requirement for the privacy notice, but it's not a new one. What is new is that the requirements under the CCPA are different in kind than every statute that came before it. So in this chart, I realize it's hard to see, but I've lined up US federal laws, if they apply to you, most US state laws, GDPR, and then CCPA. And here you can see CCPA has been selected for each one of these issues. There is no other law, single law, that got selected for every issue. So even you compare it to GDPR, which had the most comprehensive privacy notice disclosure before the CCPA, there's still 2 deltas. One is including a do not sell representation or an affirmative statement that you do not sell. And then 2 is describing the information that they share with service providers. You could also say there's other details here which are not captured in this chart, But there's a requirement that you disclose by enumerated category in California, meaning if you have a fully compliant GDPR privacy notice that fully discloses all your privacy practices, I've never seen one yet that disclosed by enumerated category. The enumerated categories are specific categories of information that were identified in the CCPA that don't match over to anybody in the privacy world's conception of what were the important categories of personal information. Some of them do, some of them don't, that now have to be enumerated in terms of whether you're collecting, using, sharing, disclosing, selling. So what should companies do? Review your privacy notices, identify instances in which you may be collecting information about Californians and you don't currently have a privacy notice. So a lot of companies had privacy notices, but they were not omnibus umbrella notices. They may apply to online collection, but maybe not offline collection. Or they apply to consumer data, but not employee data. In such situations, where you find a gap, draft a new privacy notice, or at least conform your existing privacy notice to the new requirements of CCPA. Number 2, data subject request protocols. Again, on some level, nothing new under the sun. There were already statutes that had access rights, deletion rights, opt-out of sale rights. But there was not one omnibus one that was going to hit most companies in California or in the United States. Instead, you had access rights under HIPAA, FERPA, GDPR, deletion information under COPPA, California Eraser Button Law, and GDPR, and opt-out of sale under GLBA and some of the state analogs of GLBA. Now, let's say pre-CCPA, this may have covered 10% of the universe of businesses. Post-CCPA, we're in a world where this probably covers 80 or 90% of businesses. So what should you do? Review existing methods for submitting access and deletion requests if you have them. Review existing policies or procedures for authenticating individuals. When somebody says, give me access to my information, you don't want to just hand over all the information to that person, not knowing who they really are. If there's no authentication policy, draft one. So at some point in time, your organization will inadvertently release information to the wrong party, whether that's inadvertently or because of phishing or because somebody's attacking. The best way to defend that is to have a written protocol and policy for how you authenticate and show that you had a reasonable basis for and a consistent method in terms of authenticating individuals. Draft a playbook with standardized communications. Again, we can talk more maybe in the panel discussion about the frequency of data subject requests, but for most of our clients, it's either an all or nothing, it's binary. Companies will get 1 a year, and then all of a sudden, there's reasons for this. They may start getting 10 a day. And so if you don't have standard communication templates, you can get overwhelmed overnight. Or if you're not checking your privacy inbox and a week goes by and you start getting 10 a day, by the time you check it, you could have 100, 150 requests. Train employees on how to handle. Verify that the policy in place facilitates the fulfillment of requests. Review protocols for the deletion of information, and review technological capability for doing a hard delete. I can't overemphasize this one, and it's not just you, it's your vendors. So your vendors who you're sending information to, you probably need to do a flow down obligation. So you get a deletion request, you're going to delete data that you aren't allowed to keep under the CCPA. You then have to turn to your vendors and say, please delete the information. Not all vendors, even if they put in contract that they will, can. And so part of the due diligence here is trying to figure out which of your vendors have that capability. Marketing practices, I'm not going to spend too much time on this because we could spend easily an hour in terms of what this means. It's very confusing from the language of the statute, and then the proposed regulations make it even more confusing. I'm just going to leave it with saying you can't discriminate on the exercise of rights. The one that seems to cause the most concern for most businesses is deletion right. So most businesses don't discriminate when somebody says, I want access to my information. They don't discriminate if somebody says, I don't want to sell my information. But when somebody says, delete me, a lot of businesses have a hard time still doing business with the person. Like, how can we provide you with services if we are going to delete you? How can we send you coupons if you don't want to be on our mailing list? And if we don't send you the coupons, are you being discriminated against because somebody else got an exclusive coupon? There's a lot of situations here which I don't think were really anticipated in the drafting, but do play themselves out. So in terms of practical areas, the 2 places where most, at least B2C companies, focus: loyalty programs and trying to make sure the loyalty program is compliant, or at least materially compliant with the CCPA, and then exclusive deals and mailing lists, those situations where you'd be sending out coupons, discounts, different rates to people because they signed up. What should you do? Review pricing practices and policies. Most companies don't think they are discriminating until you start getting into the weeds of talking about loyalty programs and mailing lists. Review existing privacy notices and verify that they meet the new requirements of the CCPA. If you are discriminating and if you are trying to exercise an exception, because there is an exception there, where there's a reasonable relationship to the value of the data, there needs to be disclosures about what that value is. That can be very tricky in terms of drafting and substantiating. Draft an appropriate policy for managing requests, train employees, verify that policies in place facilitate compliance with the new requirements of the CCPA, and then be prepared for the proposed regs when they go final, and then they make you do all of this again, because those proposed regs will probably have to be amended in some portion. 4 and 5, this goes to the security issues. Written information security plan and incident response, and as I said before, the CCPA does not require that an organization implement an information security program or a written one, but it does increase the penalties if you are found to have unreasonable security following a data breach of sensitive category information. It's important to note that this particular provision of the CCPA does not use the same broad definition of personal information that the rest of the CCPA uses. It uses the more traditional sensitive category list of information, so social security number, financial account number, driver's license, biometrics. How does it compare with European law? High level, there's a similarity in terms of California standards and European standards for how you're protecting the information. The regulatory penalty pales in comparison to the GDPR. GDPR by far has a bigger regulatory stick. But nobody cares about regulatory actions in California. They care about the private class action bar. That's what California is famous for. And at $750 is the maximum statutory liquidated damage per consumer after a breach happens. It's not hard to get to bet the company dollar amounts when you're dealing with a potential class action of $750 per consumer. You could lose 10,000 records and be in a bet the company situation. Previously, breaches on that level, 1,000 records, 5,000 records, 10,000 records, did not materialize into class action litigation. Overall, just to give context, the conversion rate from a data breach to a class action hovers around 4%. So 4%, if you look past in the past 6, 7 years, about 4% of the publicly reported data breaches will end up with a class action litigation. That number will be worlds different next year. That's too big of a carrot for the plaintiff's bar to ignore for even the small breaches that previously they thought were insignificant. What should a company do? Memorialize security policies. If you don't have a written information security plan, it is time to write one. This can be one of the only documentary pieces of evidence that you have if you are in litigation following a data breach to demonstrate that you had reasonable security before the breach occurred. Review your WISP to see if it conforms to industry standards. There's very few statistics in terms of what companies are doing and which standards they're adopting, whether that's NIST, ISO, PCI. A lot of companies historically have not followed an industry standard framework, or they use one as a framework, but softly. They deviate from it. The importance of trying to stick now to something that is a recognized framework because it may be helpful in showing that you're reasonable has skyrocketed for California. Review the substance of your WISP on an annual basis. Conduct periodic risk assessments to identify the primary risks. These are basic data security hygiene practices, and then train your employees on security practices. Finally, vendor management. CCPA defines a service provider as having a written contract that prohibits the entity receiving the information from retaining, using, or disclosing the personal information for any purpose other than for the specific purpose of performing the services specified in the contract. This seems simple enough. And I'm sure the people who drafted the CCPA thought this isn't a big deal. All vendors would have done this. As a practical matter, if you reviewed 100 vendor agreements that were drafted before GDPR, you would have probably found 95 of them did not hit this. Post-GDPR, you find some that did and some that didn't, depending on how they responded to the GDPR and how limited they were. There are still a lot of vendor agreements that allows the vendor to retain, use, or disclose for their own purposes, even if it's a very limited purpose. Think I terminate my vendor, but my vendor is going to retain the information in their backup systems because they don't have a way of deleting it. They would be in breach. They arguably might not be a service provider. Think my vendor is going to be using it for analytics purposes or to improve their products or services. That opens up a question as to whether or not that level of use would or would not violate service provider provisions. This particular issue is becoming a really hot topic, and we could do an entire hour on this in the ad tech world. So you start using cookies, behavioral advertising, and the relationships between a publisher, an advertiser, a website, and all of the third-party cookies that attach. And what you find out is a good portion, not all of them, but a good portion of those third-party cookies that attach to any website when you visit it have very questionable basis as a service provider using this definition. And if they're not a service provider, it opens up the gambit that you may be actually selling the information, or the website may be selling the information. When a consumer goes to walmart.com and gets 100 cookies downloaded on their browser, if that is actually the sale of information, you could be looking at a situation where compliance becomes very tricky, not impossible, but very tricky with the CCPA. So what should a company do? Review existing agreements with service providers to identify potential gaps. Identify instances in which you may be using a service provider that has access to information about Californians and for whom you do not currently have agreements in place and get one in place. And then update your agreements with your service providers to make sure that it meets what looks like a deceptively simple definition. I will talk very quickly about cookies because I kind of mentioned it. Again, going to the definition of sale, so making available, transferring, or otherwise communicating in writing or by electronic means consumers' personal information to a third party for valuable consideration, which again, this raises the gambit of transfers of information from a website to third-party behavioral advertisers. Is it a sale? And then just for those of you who are not too familiar with cookies, this is how a cookie works and operates. So you go to toyota.com, not to pick on Toyota, hopefully nobody here works for them. Double-click cookies attaching. So you can see it right there. This is in my Chrome browser. The double-click assign me a unique value. There's an argument that that unique value by itself may be personal information, or at least tied into the other information DoubleClick may know about me, such as my IP address when I visited the website. Then I went to, this is the Las Vegas Review-Journal, my hometown. And DoubleClick also deployed, same cookie, same number. DoubleClick tracked me when I went to the two sites. The concern in the ad tech community is that what happened is Toyota sold, using their definition, my information to DoubleClick, which is owned by Google. And then Las Vegas Review also sold my information to DoubleClick, which is owned by Google. And neither one of these would be compliant with the CCPA if that actually happened, if that definition holds, because neither one of them gave me an option to do not sell my information. And we can talk more about what that would even look like for that option and about the technical impossibilities of exercising that option. But that's a little bit more in depth. How did I do? Was that 20 minutes?
That was extraordinary.
There you go. That's the CCPA in a nutshell.
Thank you, David. So I quickly wanted to amend my introduction with three thank yous that I neglected to make. So the first is to Vanessa and Heather for helping to put on this event. Thank you guys so much. The second is to Brad Bernthal, who's sitting in the back there, for letting us co-opt his crash course series to put on one about privacy law. And the third is to our executive director, Amy Stepanovich, who is behind the scenes making all good things happen. Okay, so with those three thank yous, I'd like to turn to our panelists. I want to start by giving Chris and Liz a little bit of an opportunity to amend the presentation, should you want to. And given that it was done in 20 minutes, this is no commentary on David's thoroughness. Are there any particular elements of the CCPA that you would want to highlight for this group as being key to compliance that David didn't necessarily cover?
So I'll start. You want me to start?
Yeah, go for it, Chris.
So one, before I answer the question, I just want to say one thing. I saw a lot of people taking pictures out there, and I want to say, I mean, both David and Liz are amazing at putting their resources out. So if you feel like you maybe didn't capture some of this, like I think I've seen every one of those slides. Somewhere, yeah.
We can also send it to anybody who wants it.
Yeah, but I mean, really, like, I just want to say, one time if you went to the GDPR crash course, one of the things I loved that we talked about was resources. And if you just, look for resources for both these two, they're putting out tons of awesome free resources. So would I amend any of them?
What did I get wrong?
Yeah, what did you get wrong? I don't know, nothing
no
wrong.
No pressure.
Yeah, no pressure, I know, geez. So one thing that I guess I would basically maybe just take another step down that seems to be hitting a lot of clients is with regard to the different types of notices. And so we talked not just about privacy policies, your generally like publicly available privacy notice, but really you have to think of the collection. David mentioned this with regard to online and offline collection. That's a very big step forward compared to what you have with most US privacy laws. You also have employee aspects of that notice requirement that is going to hit many more companies. And the really difficult thing there on the notice is that you have different requirements under the CCPA. One of the amendments that David was talking about He talked about transparency rights, and then we talked about access, deletion, rights to opt out of sale. Some of those rights apply to the employee notice, some do not. Some wouldn't make sense to apply to the employee notice. We are in a 1-year transition period, and we'll see if that gets extended, but that's a hard thing to manage because the inclination, when you read the definition of the CCPA, it mentions employee-related information. And you think, in a lot of companies, maybe if they receive a package or like a productized CCPA kit, they throw that in their privacy policy, they talk about all their CCPA rights, and not all those rights are actually available, nor would they grant them to their employees. So, that's another thing I would take another layer down. And then maybe just one other piece on notices is with regard to cookies. David talked about cookie management, but really there's almost, the idea of cookie banners really has to take a step forward with a little bit more transparency with regard to cookie notices. But that really works with what David was saying. Those are the only things.
Can you just take a second and explain what a cookie banner is?
Yeah, so a cookie banner, see, this is, you've seen it. It's that pop-up at the top. It shows up in different forms, bottom, top. It's basically that one disclosure statement with regard to how you use cookies on the website. The problem is that throughout, and Liz has, I'm sure, a lot of things to say about this, and I know David's been publishing a lot about this recently, is with regard to guidance from different EU member states on how you can implement and when you can use a cookie banner, when you cannot specifically use a cookie banner, and what level of choices you have to give with different categories of cookies. It is now, the transparency requirements with regard to cookies are such that it is very difficult to stick all of that detail into a one-sentence banner and give granular choices with regard to different categories of cookies. And so it really dictates that you need to provide something more than just a cookie banner, like a one sentence. By using this website, we're placing cookies and taking all that information. So,
I'm going to answer your question, but I can't resist sharing a quick anecdote on cookie banners. I had a client under GDPR, and their marketing folks would not agree to deletion of data, and they had, I kid you not, probably about 30 years of consumer data sitting on their systems or in storage. And so we got to the point on the legal team and the compliance team of saying, for every year that you want to keep extra data, we're going to increase the font size on your cookie banner by 1 point. So you can get a bigger cookie.
30-point font.
that's awesome. That's the way to do it.
So in case you need any leverage there. What would I add? I guess I would go right back to the beginning on this and say that for most organizations, it's really, really hard to comply with any of these requirements around notice or data subject rights or sale of data unless you know what data you are collecting and using. And that sounds really simple, but for a lot of organizations with either a lot of legacy systems or even newer organizations that are just not that sophisticated on the privacy front, not knowing the types of data that you have and why you use it means that it's really tough to deal with those data subject requests. So I guess when I'm talking to clients, I'll say the starting point is a data inventory. It's a data map. It's analogous to what we saw under GDPR with the record of processing activity. It's not mandated under CCPA, but I'd go to bat on the comment that you really can't comply unless you have that understanding. Because for the data subject rights, not everything, those data subject rights are not, or consumer rights, look at me, I'm in my GDPR talk, they're not absolute. So, I quite often have clients who'll say, well, if we have a deletion request, but we're in the middle of processing a transaction for this person, how can I delete their information? Well, of course, you can't, But to not understand why you need to keep it, can lead to a lot of confusion there. So data mapping is my big sales point.
So I'm going to feed you another potential one that came up in David's slides, but maybe wasn't highlighted in the way I was thinking about it, but the issue of purpose limitation or purpose specification. So all of these laws are built on a set of principles from the 1960s, 1970s called the Fair Information Practice Principles, which generally include the structure that we've seen in both the CCPA and GDPR of individual rights on the one hand and company responsibilities on the other. One of the company responsibilities from the FIPS, or the Fair Information Practice Principles, is a responsibility of naming what purpose you intend to have the data for, And I know there's been some discussion with the CCPA about whether it in fact contains a purpose specification requirement. So I was wondering if you could speak to that.
You want me to start?
Yes.
Okay. I mean, I believe it does.
Yeah.
So yeah, and it's very clear. I think it does in the statute, but it's very clear in the regulations that what is not clear is there's two types of notices that you have to give under the regulations. There's a notice of collection of privacy policy, and they can be combined, but they don't have to be. But it is one requirement, very specific, very clearly stated in the notice of collection, that you have to list categories by purpose, or purpose by categories is how most people interpret it. But that you have to list purposes for certain categories. And if you change that purpose, and this is new, you have to get another disclosure. You have to get another, you have to provide transparency again, and then you have to get some type of authorization, so it's linked there. Yeah, I mean.
Yeah.
I think what's up for debate is how specific you have to be for the purposes. So if you read the CCPA literally, there's a list of purposes you have to choose from, which does not match the list of purposes for the GDPR. And so if you are a multinational company trying to comply with both, you can end up, so I was just reviewing a privacy notice that was 42 pages long, which violates every FIPS principle about transparency and accountability. But they had tried to put everything in it. We're going to comply with everything the CCPA requires, everything the GDPR requires. We're going to comply with citing statutes of various jurisdictions. So what I think there's more art than science here is how you can accommodate the CCPA, get to the intent of it, of disclosing by purpose, without necessarily letting the tail lead the dog, right? If you try to, on that particular issue, I think, stay to the exact language of the CCPA, you're going to find yourself violating other statutes or creating an unworkable privacy notice, or a California-specific privacy notice, which is also unworkable for most companies.
I think that raises a good point for companies that operate across international borders, is that you have this sort of hodgepodge of legislation. There is, if you think about it as a Venn diagram, there is the middle of that Venn diagram where you have some very similar concepts that I think you can generally address. But the sort of the art form, or the danger, I guess, is to David's point, by specifying a number of rights on an absolute basis too closely to what the legislation says, you're setting yourself up, because you're taking on liabilities or making promises that you otherwise might not have, or you're not quite getting to where you need to be on those promises, in which case the FTC is going to be, quite interested in talking to you as well as the California regulators. So I feel like you could do an entire sort of 101 at the moment on drafting privacy notices, not in a legal way, but just in a, can we sit down with somebody from the, a consumer expert and say, how can we draft these to make them actually workable?
Yeah. But I think to your point about the data mapping, right? The way you start compliance on any of this is to know, excuse me, what data you have and where it's going.
Yeah.
There's also the suggestion now, requirement under the GDPR, to the extent the GDPR has requirements, and under the CCPA to the extent that the regulations are dominating, that you need to know why you have the data,
Yes.
correct?
Yeah.
Yeah, so it's not just what do I have, where is it going, but also why do I have it, for what reason?
And that comes into play really as well with retention, again, on the deletion side. I think there's a tendency to look at personal data as just sort of one set, and I try to think of it in silos of use. So you might lose various silos of use through a deletion request, but that doesn't mean that it's across the board. But likewise, people have a tendency to think, well, I don't have to delete it because I need to keep it for this reporting requirement. And then there's a misconception that, well, that means I can keep it generally. And it's like, no, it's more an access request, an access rights issue, I think, than a retention or deletion issue.
Yeah. I mean, it's so true. It's like privacy policies, the drafting of privacy policies used to be this very form exercise. You would have a privacy policy, and you basically ask if they were doing behavioral-based advertising for a disclosure, and if you're sharing it with anyone weird. But now it's an advanced level of Tetris. It's kind of like you have to know categories by uses and disclosures by categories, and then lawful bases by uses. And tying those against a common language across multiple statutes is exceptionally hard. I mean, you know, I think David's got a great point, like with regard to uses, and you have the categories of use that are listed in the CCPA. He also mentioned you have to disclose categories of collection for personal information with regard to the categories in the CCPA that are illogical. And I've seen, you know, a lot of time, if you look at them, they reference California statutes. And I've seen people just put out types of data types that are only in one California statute. You know, that makes no sense for a global company. You know, and similarly, you have another problem with regard to the rights with regard to that data. I mean, even amongst this panel, I think you would find potentially some disagreement with regard to, does the right to opt out of sale, is that a right of restriction? Or is that something that's included in a right of restriction, like in a GDPR sense? Or is that something wholly separate from a right of restriction?
I mean, to echo what Chris said, there was a time about 4 or 5 years ago when I think companies looked at drafting of privacy notices as a commodity. There were some law firms that had privacy notice generators, some notable law firms.
Yeah.
Given the complexities of CCPA, GDPR, the states, understanding the other laws, drafting a privacy notice is not an easy feat. I mean, it is not something that if you are not steeped in privacy law that you should be attempting to do, because 9 times out of 10, you're going to shoot yourself in the foot inadvertently. In the interest of trying to disclose correctly and accurately, you will violate 1, 2, or dozens of laws simultaneously. And that's a shame, because, you know, I think one of the drawbacks, which we'll probably all discuss on the panel, is the regulatory burden of the CCPA is enormous. It is a statute that is designed to have an internal data privacy officer or an attorney who knows data privacy. And when you're dealing with particularly smaller companies or startups where you got 10 employees, none of which have a law degree, you don't have the budget to be retaining Liz or to be retaining Chris. Right. And you're trying
not to be retaining David.
No. And then you're trying to comply. You're trying to do right. You start turning to things like drafting your own privacy notice, doing generators. That stuff will land the company into more problems so quickly. And yet there's no real good solution to this. The statute and the issues are too complex to allow business to do it, which is, I think, a shame. I think that's actually a step backwards.
Yeah, I think that's right.
I want to, because we are getting into the weeds of privacy policies, which, as one would expect on a privacy crash course, bring us back up a level and ask each of our panelists, if you had to, and this is hard for lawyers, if you had to sum up CCPA compliance in 3 words, what would those be? Margaret told us this ahead of time, so I actually prepared mine. And I'm going to cheat, because I'm going to take out the verb and the Sure.
Yeah, okay, there you go.
Sentence.
So, perfect, enemy, good. Okay. Right? Perfect is the enemy of the good. Like when you're dealing with CCPA compliance, there's more art than science. Perfection, 100% compliance is not attainable. It's a statute that was not drafted clearly enough, well enough to get to 100% compliance. And so my practice, and it'll be interesting to hear if Chris and Liz are the same way, it is about risk mitigation, and it's about making risk-based decisions on every aspect of the CCPA, whether it's privacy notice, cookies, sale, loyalty programs, affiliate sharing. All of that requires some understanding of the risks, because there really is no perfect one-size-fits-all position. Those are my 3 words.
So I promise we didn't synchronize on this, but mine would be progress, not perfection.
That too.
Yeah.
And that's 3. Progress, not perfection.
I know. You must. I think there's a tendency, and particularly amongst smaller companies, again, as David said, that have less budget available to them, to look at this and say, and almost freeze. It's the sort of the we're not going to do anything because we don't have the budget to pull in a law firm to do all of this work. And so I think looking and saying, okay, what can we do? What's the low-hanging fruit, right? Can we look to see if we are, can we do some analysis? Are there obvious points of sale of data? If we know we're selling data, we can easily deal with that. Making sure you know where the data sits. But I think it's better to do something subject to the risks, again, on that, doing something yourself and messing it up. But you're not going to get to perfection on this piece of legislation.
I apologize, Chris, for interrupting before you get your 3 words, and it gives you time to think of it if you didn't prepare. But what I'd say is, there's a sense with Europe's version of this, with Europe's GDPR, that regulators really are looking for good faith efforts as much as anything else. Do you, either any of the three of you, have a sense that that will also be true of the California AG? It clearly won't be true of the class action attorneys who are going after the liquidated damages provisions, but California AG, similar in attitude to European regulators on this front?
I would hope so. And I think the reality probably is yes, apart from anything else because of a resource limitation. You know, the California AG just isn't going to have, at the offset, the resources to go knocking on people's doors to say, hey, show us your privacy notices, show us your compliance.
My fear is that there's a fundamental difference between Europe and California. So Europe has supervisory authorities which are highly steeped in data privacy. Right or wrong, they understand data privacy. I think the Attorney General has shown he does not, nor does his staff. So, I mean, he's proposing a regulation which would require companies to comply with a technology that doesn't exist. And he recognizes it doesn't exist, but he's going to require companies to comply with it. I think there's a naivete that is not thinly veiled, and that worries me because he's showing all of the, Marina Olhausen of the FTC used to have the great phrase of regulatory humility, that regulators should not presume that they understand how the business world works. They should learn from the business world. The Attorney General of California does not have regulatory humility. I think he has a presumption about how the business world works that is incorrect and wrong and frankly scary.
Yeah.
But to Liz's point, I'm not scared of the AG. He has staffed up 20 attorneys, you know, and he has 500 million companies to go against. It's the class action bar. And that's what the name of the game is in California, and they are not reasonable.
And we will come back to risk assessment both for smaller companies and for smaller companies in Colorado specifically a little bit later. So Chris, your 3 words.
Yeah, and I agree with everything you just said. Well, and let me add to that just one thing before we just move off this point. I mean, it was really
Not 3 words.
This is not 3 words. It's not 3 words, but I think it's such an important point because, like, I mean, I wish I would have done like a risk-based 3 words. So now I'm like, oh, that was so smart. I mean, it is. It's risk-based. You think of like in the California AG when this first was passed, no additional budget was like, I'm out of the game. Like they sponsored a bill or an amendment that said that they were going to give it all up to the private right of action, and they were going to be out of the interpretive and enforcement authority. That amendment failed, so which is probably good. So we're not like fully subject to the plaintiff's bar, California plaintiff's bar. But importantly to note, the California AG has gone in the entirely different direction when they came out with the regs. I mean, and it's so important, and David indicated some of these numbers that came out with the study that came out with the regs, but basically hiring 20 attorneys, planning to spend $5 million next year on enforcement. And the regs just fundamentally were at a different beast. They added new obligations than what we were expecting. So and it goes to the fundamental misunderstanding of how, and the obligations go to the fundamental misunderstanding of how businesses work. So, I mean, it's just, I didn't want to leave that just hanging out there. I'm going to go a different direction with my 3 words and kind of bring us back to kind of essentials here is that rehashed privacy reality. I mean, rehashed in that, how many times have we mentioned GDPR here? Like, if you have experience in the GDPR, so many of those lessons bear weight here. It's not that I want to be very clear. It's not that, hey, you did GDPR, we're done with CCPA, don't have to do it. That is not what it is. But there is this rehashing of privacy rights and obligations, and there's concepts that you can use from, if you've already gone through GDPR compliance exercise, yet you can use, some you can't. But you look just, you know, in general, all surveys that are out there say companies that were prepared for the GDPR feel more prepared for the CCPA. So, you know, do look to those lessons to the extent you have them, and I know we all rely on them. Privacy, because it is a fundamental privacy law, which is really new to the U.S. And then reality, just it is that almost hysteria, like this is not going away. This is the future. We're not. I still am getting like, when is federal legislation going to preempt this thing? Like tomorrow? Did it happen any moment?
Yeah.
You know, like
They're occupied with some other things.
right. They have a few other things to do, and next year they'll have a few other things to do. So like, it's reality.
One thing Chris said, I mean, there's so much GDPR lessons to be learned that the reason Chris and Liz are such good CCPA advisors is because they both really know GDPR. You know, the scary part where we've seen the biggest mistakes by lawyers are people who don't know GDPR, and then they're delving into CCPA because they read the statute and they think they can do it. If you know GDPR, there's so much to build on.
Yeah.
Yeah, I think that's where I've seen the best counseling and advice come out of lawyers is those who like these
Just
two.
that.
know it.
And David.
And Dave, yeah, I mean.
So everybody on this panel loves each other, which is wonderful.
Get us talking about which cookie banner works and some divergence probably.
So one thing I'd say to that, I think I'm actually going to go to the GDPR question next because it's directly relevant. Before I get there, though, one thing that's interesting, when you look at the GDPR's requirements, accountability is a core principle, right? And there's a huge amount of emphasis on explicitly requiring a data protection officer or explicitly requiring risk assessments, and basically trying to require the elements of a good compliance program. One of the things I've heard said about the CCPA is that while it doesn't necessarily specifically require these things, it effectively relies on the scaffolding or the skeleton that you've built up in the GDPR process in order to do anything that you need to do under the CCPA. So I guess I can form that in the form of a question. Agree or disagree?
Yes. I think I would largely agree with that. GDPR mandates, as Margot said, mandates a number of items. The problem, I think, is that, so the data protection officer, the nominated person, that worries me less. That has all sorts of issues under GDPR, which are nonsensical, in my opinion. But under CCPA, I feel like it's just good practice anyway to have somebody within the organization who really has a handle on privacy. But around some of the other scaffolding, privacy impact assessments, risk assessments for new modes of processing data, those are just good practices to have anyway. And to the extent, because they're not mandated under CCPA, you don't have that same, it's almost the same but a little bit different concern. And so I think to the extent that you have those pieces of scaffolding in place, pulling them into force is not a bad thing. In my opinion is, if you're, in this day and age, if you're a company and you're dealing with personal information and you're coming up with a new project, it should just be second nature in the way that you develop that project, that you think about the privacy impacts. It might not be, but
So to go to the question that I had distributed, if a company is already in compliance with GDPR, and I know there's no such thing, but if a company believes that it's primarily in compliance with the GDPR, what are the biggest changes it would have to make once the CCPA comes into effect?
Yeah, you want to start?
go for it.
Sure, I'll start with it. So every privacy notice needs to be revised. There's no GDPR privacy notice that would work for the CCPA. So if you are GDPR compliant, it may not be a heavy lift, but if you're GDPR compliant, you need to put pen to paper and revise your privacy notice. So that's a given. The other one, which just doesn't exist in the same form, is sale. So GDPR has a concept of objecting to processing. And one of the objections you can do is if you are transferring information to a third party under the legitimate interest analysis. These are all technical words for the GDPR. But it gives us limited right to be able to object to some transfers to third parties. But that is really not a full-on analog to what the CCPA does. And the CCPA focuses on this concept of sale, and it defines sale in a way that is not how the dictionary defines sale, which means every company that thinks that they were fully compliant with the GDPR and had opt-out rights and had legitimate interest analysis, they need to re-examine whether their transfers to third parties might be a sale. If they are a sale, they need to patch up those agreements with the third parties, and or they need to deal with this opt-out of sale issue and how to effectuate it, how to police it, how to make it work. Those are the two big issues, I think.
Yeah, I would say, how you deal with access, deletion, and rights to opt out of sale. It was, I would say, when I read the CCPA, I still thought that with regard to individual rights, GDPR was the high watermark. And then the regs came out on October 10th. The proposed regs. Yeah, so I know, but the regs came out, and basically that's now the new high watermark with how the process that is required for how you accept those types of requests, how you authenticate a user. and what is required to authenticate a user, and then how you respond to those requests and what exceptions, and there's even like new talk of right not to ignore, because there's notices that have to be provided whether you're granting the request or denying the request, and how you treat different parts of the request. It is so much process now that GDPR doesn't get you there.
I'm changing my 3 words to proposed regulations bad.
Oh yeah, yes. I agree, I want those too.
I'm going to just differ a little bit to what David said. So I take your point on the sale. I think there's a big difference in that. The concept of the sale is not dealt with under GDPR. But I think the concept, there is a part of that concept that is dealt with, and that is in the designation between a controller and a processor under GDPR. So a lot of people automatically thought under GDPR, if you're a service provider, you're automatically a processor. And there's a misconception there, because a number of service providers are in fact controllers under GDPR. Because
Can you give us a quick, very quick overview of the difference between those?
Yes, sorry. So a controller is the entity that, or the organization that determines the how and the why of the processing. What happens with the data, why is it collected, and what's it used for? And the processor effectively performs the operation of the processing on the data on behalf of the controller. So people looked at that, and for a long time, and pre-GDPR, this was less of an issue because the liabilities were less. But people looked at that definition and said, okay, well, if you're a service provider, you're automatically a processor. And that's not strictly true. If you, under GDPR, are a service provider but are using any data for your own purposes, so the similar thing around keeping it in an archival system, de-identifying it yourself to use it for analysis purposes, then actually that probably pushes you over into the realms of being a controller. And I think that concept's really similar when you look at the sale of data, because what we're saying here is, okay, if my service provider is able to keep that information for its own purpose, then it's potentially a business, not a service provider. Likewise, if it's able to use that data, de-identify it itself, and use it for analysis or to improve its service for the greater good of its entire customer base, not just me, then arguably that's a sale as well. And that pushes it over into being a business potentially. So I think there's you can look on that tight definition and say, actually, kind of, I guess I'd say, if you did your work on an analysis of your vendors under GDPR to truly see if they were processors or controllers, then you can apply that same analysis for business and service provider and the sale.
So you're more optimistic about the primary company being the controller or the business, and the second provider, the service provider, not being considered to be fully in control of the data if you're already GDPR compliant?
If you did that analysis.
Okay.
And that's a big if.
That's a big if.
Because that is a nuance that, going back to David's point around, kind of having that long-term view of privacy enables you to look at these issues and, not, wanting to cast aspersions on our privacy colleagues outside of this room, but that doesn't always happen.
Yeah.
David, do you have a thought in response to that? Or?
No, I think that's it. I think you're right that there's an analog there. If you are truly a processor, and if you negotiated that agreement to be broader than the GDPR, then you would also be a service provider.
Yeah.
If you were truly a processor, right? So there's the if. And if the original contract you negotiated didn't say for data subject to the GDPR. So if it said for all data everywhere subject to any law. And then there's the analog. What's different, though, is this concept of having a do not sell link. So
yes.
the GDPR doesn't require that. The GDPR says, look, you have to tell them they have the right to object. But when they object, you don't have to do anything besides decide, based on the objection, whether or not you're going to honor the objection.
Yeah.
And you may decide that you're not going to honor it. You may decide that your interest in selling the data actually outweighs their interest in having you not sell it. You can do that analysis. It's not a black or white. What's new in the CCPA is there's a link. You press on the link, and it says, I don't want it sold. And there is no exception to that. You cannot sell it. And sale can mean it going to your vendor if your vendor didn't sign the right contract. And now you cannot send it on to your vendor, or you theoretically have a violation. And then to go to the bad proposed regulations, it would get even worse, where the Attorney General said, oh, by the way, it's not just the link. If any user downloads anything to their computer which broadcasts any signal, which tells you in any way that you don't want the information sold, you have to honor that. You have no option. It doesn't matter that they're broadcasting in a language you don't understand, in a code that you don't understand, in a technology you've never seen, from a browser or from a third-party service provider that you don't know or don't trust. It doesn't matter. You have to honor that. And how it's written, it sounds like strict liability, where a company must respond to a do not sell signal broadcast through any browser, any plugin from any company. And once they get that, they have to automatically filter this through to their vendors, if their vendor didn't sign the right agreement, to the people they are actually selling data to. That's a sea change. I mean, I think that shows the naivete, again, of the Attorney General versus the working party and what was happening in Europe, where they had a better understanding that they needed flexibility by allowing the opt-out to happen, not the opt-out, the objection to processing.
So one thing I want to bring us to discuss, which actually was not on my pre-shared questions, so you're all pre-warned now, you're on notice, is that there was a lot of hoopla around the GDPR's right to be forgotten. How many people here have heard of the right to be forgotten? Yeah. So the GDPR's right to be forgotten received an enormous level of response in the US, largely from First Amendment scholars or First Amendment proponents who looked at it and said, this seems to be violative of various free speech rights. You're telling people to stop talking about you, which is not quite what the right was, but that's the general idea. It seems, at least our discussion is starting to say, that in some ways the CCPA's opt-out of sale, not the CCPA's right to be forgotten equivalent, which only applies to those companies that directly have collected information from a person, but the CCPA's opt-out of sale requirement may actually in practice prove to be significantly more burdensome if you're a company, more substantive if you're an individual of a right than the GDPR's right to be forgotten.
It all hinges, and none of us know how far that definition of sale is going to be interpreted. I mean, the best scholars that I read on this subject basically are like, it could be interpreted this way, so prepare for it. And I mean, we should prepare, but it could be interpreted this way. I mean, is the other valuable consideration with regard to a sale, is that a peppercorn? Is that a contract peppercorn, or is that, something else? So,
well, and yes, that point, I mean, you're making me think about a particular scenario I've been looking at recently with, the use of AI and bots. I mean, this technology learns through the ingestion of data. And I'm trying to phrase my words now to sort of avoid any client confidentiality issues, but I have a client who has these very real issues. Their entire product is based around machine learning. And if they receive a deletion request, there's an argument about, is the fact that they're using that data to improve their own algorithms a sale, and if they receive a deletion request, they don't know that they can actually find that data on an individual basis. And so this is, again, an example of, I think, where these laws get written without truly thinking about the businesses that they could impact, and really an understanding of actually how technology is working these days.
So would it be fair to say that the GDPR contains a lot more opportunities for risk assessment balancing tests to allow companies that are using data in certain ways to effectively, I don't want to use evade because that's too normative, but effectively get out of some of the more stringent requirements that would full on stop them from certain practices versus the CCPA is written in more absolute terms, or is that?
It's not get out of the requirements. The CCP or the GDPR built in flexibility.
Yeah. It
built in the recognition. This goes to regulatory humility. The recognition that regulators don't understand all the implications that are going to happen, and therefore there has to be accountability, and businesses have to weigh stuff.
And a reasonableness test.
A reasonableness test. And I think the CCPA ignored that. I mean, it did not exercise regulatory humility. It exercised there's going to be a black and white rule, and we're not going to think about AI. We're not even going to consider it. I can guarantee you that not one person who drafted the CCPA for a second thought about loyalty programs, discount programs, mailing lists, artificial intelligence, self-driving cars. They didn't think about it. And because of that, they now have a set of rules that don't work in these use cases, or that would require industry to really fundamentally change in a way that I don't think they anticipate. And one of the interesting things about the financial impact assessment that the Attorney General had to publish was that the third-party consultant, the Berkeley Consulting Group, said that it's going to have a 1.8% impact, negative impact on GDP, gross domestic product. 1.8%, and that was the proposed regulation, not the underlying act.
Yeah.
So we're talking about like wiping out GDP growth for the state of California, which really is the US, because what they weren't analyzing is what the impact would be on every other state like Colorado, but the impact should be the same. If you follow it, really wiping it out. And I think if you look at the math, they grossly underestimated how they came up with that number, grossly. You know, they estimated a company will spend $1,000 to come into compliance with the CCPA.
Yeah.
They'll spend $1,000 talking for the first hour with their lawyer about what the CCPA is.
Right.
Right? And then the next $100,000 coming into compliance partially with the CCPA. So, I mean, I think, again, that shows that lack of regulatory humility. They really did a very poor job of drafting something that would be beneficial to the economy and anticipating the effects.
Well, and I think more than that, you see I don't know if you guys see this, but a chilling effect on, you know, new initiatives as well. I mean, I have clients that have pushed back on new initiatives because those initiatives take them from, you know, a fairly low risk analysis to a much higher risk analysis, and they're simply saying, well, we're just not going to do it.
Right. It's also produced counterintuitive impact. So it's produced situations where privacy is actually degraded because of the CCPA. Situations where you are not going to grant a deletion request because if you grant it, you could lead to discrimination. Therefore, we just won't grant the deletion request. And we can justify the non-grant of the deletion request. But if we actually granted it, then we'd end up with discriminatory conduct. There's a lot of situations like that, privacy notices which have degraded. They were a transparent privacy notice that is now an incomprehensible privacy notice because they have to comply with this statute. That's my big worry, is that the law of unintended consequences, this was one step forward, 5 steps backwards in terms of even on the privacy advocate side.
Well, and to come back to the GDPR, if you're in compliance with the GDPR, what do you have to change to be in compliance with the CCPA? That question, as framed, doesn't leave open the possibility that the two might just not be compatible. And so the GDPR, and at least the guidelines that accompany the GDPR, emphasize very heavily that transparency is also comprehensibility.
Right.
And that your average user needs to not just receive this incomprehensible privacy policy, but actually be able to somewhat understand what's in the privacy policy. So if you're redrafting everything, thinking you're making it in compliance with the CCPA and in fact making it 42 pages, question whether you're now out of compliance with the GDPR. Chris, I'm sorry for interrupting.
No, I mean, and I was just going to say, I mean, this is a huge risk to small businesses that are caught up in the CCPA and they're trying to comply with this model that we've been talking about. We talked about the controller, processor, and under CCPA, business service provider. You know, trying to comply with that. So many businesses, the common methods of doing business. You know, SaaS models with usage data, or data. You know, hosting providers or launching websites on behalf of a client as a service provider, but doing collection on behalf of a client. Very common practices that you see all the time that have no harm on the consumer are almost very difficult to determine who's going to handle what portions of this relationship under this business service provider model. And it's a great risk because if you get it wrong, you know, if you don't have good counsel and you don't have a lot of compliance dollars, or you can't hire a DPO, but you're thrust into this, you know, compliance framework, you know, you end up taking on additional obligations. And also, I think you have an additional burden in the U.S. because of how we enforce privacy laws through the FTC. Article 5, we have Deception and Fairness Authority, which you don't really have. You don't have that in the EU. So not only are you under the risk of not doing the things you have to, but you're at risk of doing something you didn't have to and not being able to comply with it and now being under a deception authority. So
meaning you make promises in your newly drafted privacy policy, and then the FTC comes after you and said you broke those promises. So to bring us to the big startup question, what are the top 3 things startups should be worried about in particular? So you're a smaller company or newer company, you're not going to spend $100,000 on CCPA compliance. What are the top 3 things you really should be paying attention to? I think Liz started us off with this with the data mapping idea.
Yeah, data mapping. You know, data mapping can take lots of forms. You can do it yourself with some good templates and some good understanding of what systems you've got. You can spend hundreds of thousands of dollars on consultants to do it, and you can, look to a middle ground as well. So data mapping for sure. These guys are probably getting the same requests daily, hourly. The phone rings. Hey, can you update our privacy notice to make us CCPA compliant? Right? No. No, I can't. I can update your privacy notice, and that's somewhat of the low-hanging fruit and the obvious one. But to David's point, I think you have to be really careful that what you're promising in your privacy notice you actually can do, because that can lead to a huge amount of problems. But I would say focus some time on getting that privacy notice up to scratch. And then I would say that the third item for me is the WISP, that written information security policy. Because that, although it's not mandated by CCPA, if you look at where the true risk right now is around data breach and the plaintiff's bar, having that WISP in place, I think it was David or Chris who made the point, that's possibly your one document that you can hold up and say, here's an example of how we tried to comply and have our security enforced. So your WISP, and then I'm going to tack one on that kind of goes with that, because I can never just stop with the three, and that's training. Right, train your employees. Train your employees about phishing attacks. Train your employees about password protection. Those are kind of low-hanging fruit efforts that you can put in on that training side.
Yeah, I mean, I'm gonna jump on the data mapping for sure. Having a sense of how you relate to the data is, there's all these different, and that's part of the data mapping. And how is the data map different than data inventory? I mean, thinking of those different, data maps more with regard to like where you receive data from and your relationship to that data, that really is going to help you understand your obligations, and is a rudimentary document that you should have. And then I also want to jump in, because I missed it on my 3 words, that don't think of compliance as an end game. Don't think of it as like, oh, I'm just going to throw up a statement out there that I'm GDPR compliant, and don't look to
or CCPA
that.
Compliant.
Yeah, or GDPR. Yeah, thank you. Yeah, exactly. Like, compliance is not this end game, and don't think of it that way when you're talking to your attorneys or any of your advisors. Technical, legal. Because it basically sets the wrong standard for you, and it will probably get you in more trouble than it's worth. I know there's this inclination to, you see all the privacy notices going out, like you did with GDPR. You're starting to see the same thing with CCPA if you're not already seeing it. And there's a inclination to say, hey, I want to be in that. I want to say that I'm that person. I want to do updates to my privacy policy. I want to do all these things. One, you have to know your relationship to the data, whether you have to make those updates. But two, just knowing, knowing when you should do that and when you shouldn't do that, and seeing the compliance burden more as a journey. One thing I love about this, I mean, we've all been to so many CCPA presentations, I'm sure, and spoken on many. The thing that I really am frustrated with many panels that I love that we haven't done on this panel is throw up our hands, and basically like, oh, the regs, they're so horrible that we can't do anything. No one can comply with this thing. So there's no path. Mm-hmm. Think of the path. There is a path. You can make progress.
But not perfection.
Yeah, don't think of perfection. Right, the end game is not perfection, and don't be frustrated if it's not perfection. Still make those steps towards progress, no matter what your compliance budget is, no matter where you want to address this. Start making those steps, and it will help you.
This just became possibly the most Boulder privacy law panel ever, in that we're talking about the journey and not the destination.
I like it. Yeah, I know.
Love it.
David, did you have a thought about startups in particular?
Just to echo what they said, I mean, look, I always feel for startups. Only about 5% of my clients are startups, and I feel for them because it really is impossible. I mean, if you have no budget, you have no lawyer, and you're supposed to be complying with a highly technical statute that is already a mess to lawyers, it really is impossible to be 100% compliant. That doesn't mean give up, obviously, right? And startups, the one good thing about startups is they're used to this. They're used to managing risk, and they're used to knowing that there's 1,000 laws out there, and they have no budget to comply with them, and they've got to juggle that. And it's a process, and they will mature, and on the maturity scale, they're going to do catch-up and back and forth. And on some level, this is no different. What I would say, though, is if you can invest any time If you have enough money to hire an attorney for 2 hours, don't worry about your privacy notice. Worry about the structure, the fundamentals, the stuff that has nothing to do with complying with anything about the CCPA. But if the structure of your business is such that you can't give privacy notices eventually whenever you have the money to draft one, and you can't opt people out, and you're going to build a database which is going to cost you $100,000 that has no deletion capability, and you're not going to be able to search for people's information in any logical way for access rights, if that structure, if the bones are not there, that's one of those stitch in time can save 9 events. If you know that, wait a minute, okay, I get it. I might have to honor a deletion request. I'm B2B. My client may tell me I have to delete the information. You can probably build that into the infrastructure. And that will set you up for in a year or 2 years or 3 years when you're thinking about an exit strategy, you're thinking about selling to Google and making your millions of dollars, and you have to build the compliance program at that point. If the bones are there and you're not doing something fundamentally wrong, then you can hire, you've gotten your 3rd round of funding, you can go hire the attorneys, they can paper over and work with you to do the tweaks and the marginal stuff to get you fully compliant. If the bones are off and your fundamental business design just does not work with privacy, you're going to find that what you thought was a multi-million-dollar company is not worth anything to Google, because they're going to look at it and say, we can't integrate this. It just doesn't work.
Especially if every other state then ends up passing a CCPA mimic, which we can talk about later. I want to make sure we do have some time for some questions. So I'm going to combine 2 of my questions into one and then open up to all of you. This has to do with the risk assessment for a small company in Colorado. So first, is there a way to read the CCPA so that there is an exception for smaller companies, small and medium-sized enterprise exception? And second, how worried, given the Attorney General's level of resources, on the other hand, the enthusiasm of a plaintiff's bar in California, should a company that's located in Colorado really be about being in compliance with the CCPA?
So with regard to smaller business exception, I mean, so I work with a lot of startups, and a lot of probably the most frequent incidents where they get caught up in the CCPA is that 50,000 records annually. There is talk of maybe raising that through amendment. That would really help. But that is probably the one where if they can fit under something, or the one that they have to try to fit under, it's that 50,000 records. It's easy to get there when you're talking about number of people and devices and a broad definition of personal information. That could be one. The other one that could appear that a lot of people, they're focused but not really focused, is how broadly de-identified or aggregate data and how easy that technology is to implement. That could become a small business exception. Those are higher bars right now, but they could be.
Yeah, and I'll just echo the 50,000. So it sounds like a big number, but I think it's 100 IP address may count as personal information. I'm going to say may. It's in the statute as a form of personal information. 50,000 divided by 365 days, you're looking at, if 150 people visit your website every day, you're covered, arguably. I won't admit it, not on tape. This is being recorded. But look, there's going to be an argument that the plaintiff's attorneys can make that you're covered. So it feels like there's a small business exception, but this is the problem is, a bagel shop, yeah, fine. They're going to fall out of it. They're going to have less than 25 million in revenue. They're not collecting information about 50,000 people. Any startup, you can make $1 in revenue. And you launch a website, and if you're successful in even the smallest of ways, right, 100 people downloading your app every day or visiting your website every day.
To be fair, 100 Californians.
Californians.
Yeah.
Yeah, that's a good point. Actually, no. It's consumers or devices, but device is not defined as being a Californian. Interestingly, another drafting error. But you're absolutely right. That will be interpreted as Californians. So 100 Californians, which raises it somewhat, but California has 40 million people. Again, you just have to have 136 or 170 people a day from California. It's also impossible to tell. So at the end of the day, think about IP addresses. You look at your weblog, and you have 150 hits from a California IP address. You have no way of knowing are those people or those bots. Is that Google crawling you or not crawling you? So there's a lot of companies that are like, I don't know, am I covered? I had 100,000 hits last year from California, and it's really unsatisfying as an attorney to say, I don't know, and nobody does. Yeah. Nor will the AG know, but what we do know is that you may get hit by a plaintiff's nuisance suit. And if you have no funding, the plaintiff's nuisance suit can put you out of business. Because to defend that, to even file the motion to dismiss, can swamp your resources, and as of right now, the insurance market is really not responding to that. So that's the real problem is, even if on paper there's an exception. That exception is a fact-intensive discovery, which means you're at summary judgment stage, which means if you're a startup business, you've already lost.
I was hoping to give you guys some optimism, but that.
There you
go. Liz, do you want to talk just quickly to the how worried should you be if you're in Colorado, and then I'd like to open it up to questions.
So, yeah, I mean, I want to broaden that a little bit. So, first of all, if you're based here in Colorado, doesn't matter if if you're still doing business with people in California and you hit those thresholds, then you're still going to be covered. But I want to broaden it a little bit to make a general comment, which is California is kind of the trailblazer here, but we've got other laws. We've got regulations in Colorado that hint a little bit to what's going on in California around the need to have appropriate security in place and the need to have data retained only for sort of specified durations. And so, and we're seeing other states. We came really, really close in Washington State. We've got Nevada, which has opt-out rights. We've got other states that are really all going to follow through. We've had commentary from states' attorney generals. I think Phil Weiser said, look, if we're not going to get federal protection here, or if we're not going to get federal law here, we as states' attorney general have an obligation to put in place laws that protect personal information. And so, to the extent you're looking and saying, oh, it's California, we don't need to worry about that, I would urge people to have in mind that it really isn't just California. It's coming. That train is coming down the tracks, and to David's point, as you're getting your startup built up and ready for investment, for funding, for sale, if you're ignoring this because you think, well, it's just California, there's a risk there that that's going to come back and bite.
Thank you. So in interest of time, I'd like to have Kelsey as our student volunteer. Thank you, Kelsey. I'd like to have Kelsey gather 3 questions, and then let the panelists choose which of those they would like to answer. Go ahead, Kelsey.
So my question kind of relates to startups, the discussion you were just having. I'm wondering how legitimate of a concern it might be that at a certain point, privacy legislation starts to become a sort of barrier to entry in these digital platform markets. I wonder if you guys could talk a little bit about that.
Do we have any other questions? Yes. So down in front here.
So I think all of you have spoken to this a little bit, but I wanted to get maybe a more specific take, and that would be, does the CCPA discuss anonymization and de-identification specifically in any capacity with regard to, request to delete in the sale? And if it doesn't, do you see that as a way to mitigate risk for those potential companies that can't delete, for example?
Excellent. And then down in front right here.
I had 2 questions. I'm going to ask the more interesting one. Do you have any of you have an analysis of how much better off, or how different, or what the outcome might have been if Professor David Carroll would have brought his lawsuit under CCPA, time warp, as opposed to under the data? I guess it would have been the Data Protection Act of 2018, because GDPR wasn't in effect regarding Cambridge Analytica's data.
Yes. Go ahead.
Okay, I'll start. I'll do the de-identification question. So yes, I mean, it does, you had mentioned anonymization as well, so let's hit on that. But yes, under the CCPA, and this was through the amendment, it's very clear, and I think it was clear before the amendment, that outside of the definition of personal information is de-identified information and aggregate information. The problem with those definitions are that they are basically nonsensical with regard to how we use those terms generally. But they have precedential weight, which is nice, especially de-identification. We have in the U.S. laws like HIPAA that have standards by which you can de-identify data. There's also guidance from the FTC that de-identified data falls outside of their enforcement priorities. And so there's useful things that we can rely on there. There are new technologies that can hopefully will be readily available that will, again, for like startups that can take you out of that if you can actually use those types of data. I mean, it's kind of a nice thing, but sometimes you need to know, you need to have data that's identifiable for the use that you intend it for. But to the extent that you can use the data in that set, it's really useful. I do want to mention that there's also, if you're looking at this issue, I mean, there's a NIST guidance on how to de-identify data. It's been out, I think, since 2010. That's very useful, and it goes through different techniques. Anonymization is basically the analog under the GDPR. Anonymization is basically a unicorn in that it basically carries that in its definition that you have to have a 100% 100% re-identification risk. You cannot have any now or in the future technique by which you can re-identify data. And as always gets cited, our famous past professor Paul Ohm proved that is not a thing. And even the European, the Working Party 29, who has put out standards by which you can anonymize techniques that you can basically work towards anonymization, has not recognized a standard by which you can anonymize data. It does create interesting bedfellows with regard to de-identified techniques and aggregate techniques under the CCPA.
So I think our remaining two questions, one was how much are privacy laws becoming a barrier to entry, and the other was Cambridge Analytica challenge, would you win this under the CCPA?
I'll take barrier to entry.
Thanks.
There you go.
Glad I went
You have another minute to think. So barrier to entry. Some of us cynics thought that and again, I think this goes to some regulatory naivete on the Attorney General's standpoint, but if you look at who was fighting the CCPA and how hard they fought, some of the big players didn't show up. So Facebook didn't show up, but probably because of the Cambridge Analytica issue. Google really didn't show up. I mean, they were there, but considering that they have more money than the state of California, they probably could have defeated the CCPA or lobbied in a more aggressive way. And one of the cynical viewpoints of it is that they're okay with it because it may kill DoubleClick. DoubleClick is one of the largest behavioral advertising companies. It probably makes $1 billion for Google. But if DoubleClick dies, because it's in the ad tech industry, it's dealing with cookies, the sale of information, the entire behavioral advertising community could die. So Google might just sacrifice DoubleClick, and then they would be left with the only 3 companies in the world that can do advertising technology on a first-party basis, meaning they don't have to sell any information because they've got their own platform and their own contact with the consumers. It would be Facebook, Google, Twitter. So on that level, I am worried about this. I'm worried that there are interpretations of the CCPA that could have really devastating effects on some sectors of the economy that could funnel the only people who are able to survive being some very mature companies with some network efficiencies that are non-replicable easily and could drive out a lot of smaller companies. And again, I don't know if I buy into the cynical view that Google was willing to sacrifice its pawn of DoubleClick in order to get the larger benefit of killing the industry. But I do think there's something there to be said that, when it came down to it, Facebook, ironically, was one of the first companies to have a point of view of how to comply with the CCPA because they had first-party data. They could advertise to people on Facebook. They could offer a solution when all of the small startup ad tech companies have no solution and still don't. So.
All right, Cambridge Analytica. Do I think Cambridge Analytica would have had, was your question, would it have had more impact or would it have succeeded under CCPA claim?
Well, I mean, his lawsuit, last I knew, succeeded in that
It's, yeah.
and it was criminal, then they fined the lower than it would be. I don't think he's gotten the data yet,
Correct.
but he thinks he's going to.
Yeah.
So I heard on October. But like I thought the interesting thing with his lawsuit was that how like he do anything to try to see what data he had. If he ever gets it, because they were in the UK.
Correct.
So like would the David Carroll of the future be in a different if this happened in the US?
So if Cambridge Analytica 2.0 happened in California after July 2020, when the state attorney general is enforcing the CCPA, what would happen?
Yes, I think we would have ended up, I think we would, not we would have, I think we would end up with a similar level of knowledge under CCPA. And I'm hesitating because I'm a little sleep deprived and because of CCPA and trying to figure this out. But yes, I think he would. So if we think about the two fundamental issues, one is the right of access to data. Right? Tell me what data you hold about me. So David Carroll would have been able to go to Facebook, first of all, in theory, and say, tell me the data that you hold about me. Tell me about sales. Assuming Professor David Carroll had not already opted out of a sale, which arguably that transfer to Cambridge Analytica absolutely would be, tell me about sales. Okay, we transferred your data to Cambridge Analytica, or Cambridge Analytica was able to access your data, because that's where it gets a little fuzzy, is around how that transfer stroke access actually worked. I think also around, so yes, I think the short answer is yes, that he would have been able to get access. I think it was easier under GDPR. I think there's a much clearer and much easier route to access under European regulations. I also think there's a culture in Europe that made that disclosure easier once the regulators, kind of were able to get involved. So that's probably not a great answer, but I think the regulations in Europe made that easier, and I do think that culture as well made it easier.
But then if Cambridge Analytica were hacked, the plaintiff's bar in California would have a field day.
Correct.
All right, so please join me in thanking all of our wonderful panelists.
Well done.
And I believe reception is starting over here where Vanessa is, and so please feel free to come up to panelists and ask them any further questions.